Ms. Schertler. I see you have props.
I did bring props. First, I'd really like to thank you guys again for honoring me last week at the Truman Kennedy dinner. I can't tell you how honored I was to get that. And that's why I'm showing it off. I'm here tonight to talk about transparency in our county government. As you guys know, it's a part of our goal, your goals and objectives. It's mentioned on the website. And customers focus, transparency, and fiscal responsibility. And the website also says the commissioners will actively participate in their success, which includes monitoring the progress of the goals and objectives on a regular basis. If you are, in fact, monitoring your goals, your progress in achieving these goals, I hope you realize that you're falling short when it comes to fulfilling PIA and FOIA requests. The Maryland Independent recently ran an article that stated the Charles County government has abided by a court order that it pay more than $44,000 to businessman Michael Sullivan to cover his legal fees in a 2011 lawsuit he filed against the county commissioners. Was this mistake made by the county attorney's office an isolated event, or is it systematic of how the county addresses PIA and FOIA requests? Last year, I filed a PIA request for copies of the applications to the openings of the Charles County Planning Commission and the Board of Appeals. The request was denied because the county attorney's office determined that the information was considered part of a personnel record and not subject to PIA. The fact that the applicants were not personnel and did not have personnel records just because they applied for a position did not change the opinion of the associate county attorney I talked with. I also pointed out that the applicants understood their information was a part of the public record because the top of the application noted in bold print, important notice, information as part of this application is available and shall be considered public information as it pertains to the Public Information Act. If you do not wish to have personal information such as addresses and phone numbers released to the public, please check the confidential box below. The associate county attorney thanked me for pointing this out and said he'd changed the form. My husband also submitted a PIA request asking for a mere list of names, and he was denied because the county said they don't keep a mere list of names of the applicants, which seems a little bit odd because as an applicant I received an email with all of the other applicants copied on it, so someone must have had a list. So the question is, was the county attorney's office wrong in denying these PIA requests? I don't know. I can't understand how withholding this information from the public serves any common interest. There is a method to appeal a decision, but unlike Mike Sullivan, I cannot afford the thousands of dollars it takes to take the county to court. I realize that denying or granting a request to the PIA is not really on you, it's on the county attorney's office. But, however, the error noted by the Circuit Court of Appeals means that the citizens are not provided government service at the highest level of excellence. A $44,000 judgment against the county does not demonstrate fiscal responsibility. Charles County, we've come a long way in transparency, but we have a long way left to go. If the illegal denial of a PIA request is an isolated event, well, mistakes happen. If the county attorney's office, when deciding which PIA request to fill, factors in the likelihood of citizens appealing those decisions, then we have a serious problem. Thank you.
And Ms. Schertler, thank you, and I hope you understand that we certainly support our county attorney's office. You've raised some very good points that will give us an opportunity to discuss that further with our council.
Great.
Thank you. Okay, has anyone else